Have you ever found yourself, just about to sign something important, maybe buying a car or renting a place or even investing,
Hmm.
and the person on the other side tells you something that just clicks, makes you think, yeah, okay, this is definitely the right move.
Right, something that seals the deal in your mind.
Exactly. Only later you find out that what they told you, well, it wasn't actually true.
Ugh, that sinking feeling.
Yeah. That feeling, that gut sense that you were somehow, I don't know, tricked or misled right before you committed, that exact experience is what we're diving deep into today.
It's a really significant position to be in, isn't it?
Yeah,
You're relying on what someone tells you for a big decision, and then discover that reliance was, well, misplaced, built on something false.
absolutely. And in the world of contract law, that whole scenario has a specific name.
It does. It falls squarely under the heading of misrepresentation,
hmm
and it carries very significant legal weight.
So, welcome back, everyone, to the deep dive. Today, we are taking a really crucial journey into contract law, and we're focusing laser sharp on misrepresentation.
And it's great that we can do this because we're basing this entire deep dive on some excellent educational materials.
Yes, materials generously made available by the University of London. We need to be really clear, this session is purely for educational purposes. It's all about helping you get to grips with these, let's be honest, quite complex but vital topics.
Think of us as maybe guides through these materials. Our aim, our mission, if you like, is to take all this detailed, important information on misrepresentation and really distill it. We want to pull out the most important nuggets,
The key bits.
exactly, the
These-
definitions, those crucial distinctions that can trip you up, the remedies, what you can actually do if you've been misled, and also how people sometimes try to, well, get out of being responsible.
Right, those clauses in the small print.
Precisely. It's all about giving you a clear, informed understanding of statements made before you sign on the dotted line.
And we know many of you might be using these materials for your studies, maybe you're gearing up for exams. So this deep dive, it's absolutely tailored for you.
We're keeping that firmly in mind.
Mastering these concepts, and just as importantly, knowing the key cases, the case law is so crucial in this area. So expect us to revisit important terms, repeat those case names, really try to help them stick. We want you feeling ready to tackle those tricky problem questions.
That solid foundation is just invaluable, isn't it?
Totally. And with that specific focus, we really want to offer a sincere good luck for all of you for the exam.
Yes, indeed. Best of luck. We really hope this discussion helps solidify things for you.
Before we properly jump in, we also want to say a big thank you to our sponsor for bringing you this deep dive, Sinorbit Academy Sri Lanka.
Yes, thank you for the support. It makes these sessions possible.
Okay, so misrepresentation. Where do we start this journey? I guess you can't really fix a problem until you know exactly what it is.
That's the logical starting point.
Right.
We need a precise legal definition. What actually counts as a misrepresentation in the eyes of the law?
Right. And you mentioned distinctions are important.
Absolutely crucial. Almost immediately after defining it, we hit this key difference.
Mhm.
Is the statement a legally binding term of the contract itself, or is it just a representation made beforehand?
Oh, okay.
The impact of that distinction has actually changed a bit over the years, but understanding it is still fundamental.
Because what it is changes what you can do about it, right?
Exactly. Which leads us straight into the different types or categories of misrepresentation. Was it fraudulent? Was it careless? Was it completely innocent? The mindset of the person making the statement is key.
And that then determines the remedies.
Precisely. That flows naturally into exploring those potential remedies.
Mm.
What legal options does someone have if they've been the victim? Can they tear up the contract, get out of it completely? Or are they looking at getting money back, compensation? We'll look at rescission and damages.
And then finally, the flip side. Can people put clauses in the contract, maybe hidden away, saying they're not responsible for things said earlier?
Yes. Can you effectively contract out of being liable for misrepresentation? We'll look at whether the law allows that.
Sounds like a comprehensive roadmap.
It covers the main ground. So let's start right at the beginning. Let's define what an actionable misrepresentation actually is.
Okay, let's unpack this properly. Before we can even think about remedies like getting out of a deal or claiming compensation because someone said something untrue, we need to know exactly what kind of statement qualifies. What hurdles does it have to clear to be an actionable misrepresentation in law? It's clearly more than just, a casual porky pie.
It really is. The law demands several specific elements are present. The core definition, and this comes straight from the source materials we're using, is this. An actionable misrepresentation is an unambiguous false statement of existing fact or law which induced a party to enter into the contract.
Okay, let's break that down. Unambiguous, false, statement, existing fact or law, and induce the contract. Each part matters.
Every single one. Each has layers of legal meaning and case law behind it.
But before we dive into dissecting that definition piece by piece, you mentioned right at the start this crucial difference between a representation and something that actually becomes a term of the contract. Why is that the first thing we need to get our heads around?
It's a critical starting point, really, because the legal consequences flowing from each are different. And historically, the distinction was even more stark.
How so?
Well, before a key piece of legislation, the Misrepresentation Act 1967, the remedies you could get for mere misrepresentation were, frankly, quite limited.
Okay.
Especially when it came to damages, getting monetary compensation.
Right.
If a statement was just a representation, your main remedy was usually rescission, basically, trying to undo the contract, but getting damages on top. That was generally only possible if you could prove the misrepresentation was actually fraudulent, which is hard, or later, under the tort of negligent misstatement from Hedley Byrne.
So, back then, if you wanted a stronger chance of getting money, you'd be arguing that the statement wasn't just a representation, it was actually a promise, a term of the contract.
Precisely. Because if a statement was incorporated into the contract as a term, and then it turned out to be untrue, that was a breach of contract.
Oh.
A breach of contract remedies, including potentially quite generous damages, aiming to put you in the position you would have been in if the statement had been true, giving you the benefit of the bargain those were available.
That makes sense.
But there was a nasty sting in the tail before 1967. If a statement started life as a representation, but a court later decided it had actually become a term of the contract,
Yes.
you actually lost your right to rescind the contract based on the misrepresentation. Completely gone.
Wow, really? So you were forced to stick with the contract and just sue for breach damages. That seems harsh if you were fundamentally misled into it.
It was a very difficult position. So, naturally, parties argued fiercely over whether a statement was a term or just a representation. Then came the Misrepresentation Act 1967, which really changed the landscape.
How did the act change things?
Two key ways. Firstly, Section 2 of the Act brought in much more extensive rights to claim damages for misrepresentation, even if it wasn't fraudulent. We'll definitely unpack Section 2 later. It's hugely important.
Okay, so better damages for misrepresentation.
Yes. And secondly, Section 1A of the Act tackled that specific problem of losing the right to rescind. It clearly states that if a misrepresentation has also become a term of the contract, the person who was misled does not lose their right to rescind the contract just because of that.
Ah, okay, so you don't automatically lose the right to undo the contract anymore, even if the statement is also technically a term. You might have both options.
Exactly. You could potentially have a right to rescind for the misrepresentation and a claim for breach of contract if the statement also qualifies as a term. That old harsh election, at least regarding rescission, was eased.
So why is the distinction still important today if the Act fixed those issues?
It's still vital for a fundamental reason. Remember the definition of misrepresentation. It's about a false statement of existing fact or law, something that is true or false now.
Okay.
If the statement made before the contract is actually a promise about something in the future, like, I promise this machine will produce 100 widgets an hour, that's not a statement of existing fact. It's a promise about future performance.
Right. It's about what will happen, not what is.
Exactly. So if that promise is broken, if the machine doesn't perform as promised, your legal route is almost certainly only for breach of contract if that promise became a term. It can't be misrepresentation because it wasn't a statement about an existing state of affairs.
Got it. So if someone says, I promise I'll repaint the fence next month as part of a house sale, and then they don't, that's a broken promise, potential breach of contract. It's not a misrepresentation about the fence's current color or condition.
That's the core distinction. Misrepresentation looks at the truthfulness of statements about the present or past.
Yeah.
Breach of contract looks at whether promises about the future were kept.
Okay. And the source materials mention courts use certain factors to help decide if something said pre-contract is a term or just a representation.
Yes. Referencing back to Chapter 5 guidance, these aren't rigid rules, but indicators the courts consider. One key factor is the relative skill and knowledge of the parties.
Ah, like those famous car cases.
Precisely the ones. You've got Dick Bentley Productions Ltd v. Harold Smith Motors Ltd on one side and Oscar Chess Ltd v. Williams on the other.
Remind me which was which.
In Dick Bentley, the seller was a car dealer, an expert. His statement about the car's mileage was treated as a contractual term because he was in a position to know the truth or find it out, and the buyer relied on that expertise.
Okay, expert seller, likely a term.
Whereas in Oscar Chess, the seller was a private individual who was just relying mistakenly on the car's logbook for its age. He wasn't an expert. The buyer, a dealer, was actually in a better position to check. So the seller's statement was held to be just a representation, not a term. Remember those. Dick Bentley and Oscar Chess. Skill matters.
Makes sense. What else do courts look at?
Another factor is whether verification of the statement was suggested or, conversely, discouraged.
How does that play out?
Well, in E.K.D. Godfrey, the seller of a boat made a statement about its condition, but also suggested the buyer get it surveyed independently.
Don't just take my word for it. Check it yourself.
Exactly. That suggestion indicated the seller wasn't intending his statement to be a binding guarantee, a term. It pointed towards it being a representation the buyer should verify. E.K.V. Godfrey. Conversely, if someone actively discourages checks, it might suggest they intend you to rely solely on their word, pushing it towards being a term.
Okay. Verification suggested maybe representation. What about the time lag?
Yes, the amount of time between when this statement was made and when the actual contract was finalized. A significant gap can suggest the statement wasn't intended to be part of the final deal.
Like it was just part of early negotiations.
Potentially. The case usually cited is Routledge v. McKay. A statement about a motorcycle's model year was made about a week before the written contract was signed, and it wasn't included in that written contract. That delay weighed against it being treated as a term. Routledge v. McKay.
Right. And the last factor mentioned is importance.
Crucial one. How important was the statement to the party who received it? The statement so vital that they wouldn't have entered the contract without it. Courts are much more likely to see it as a term.
Is there a case for that?
Bannerman v. White. A buyer was purchasing hops and specifically asked if sulfur had been used in their treatment, stating clearly he wouldn't even bother asking the price if they had. The seller assured him they hadn't.
So the buyer made its importance crystal clear.
Absolutely. Because of that explicitly stated importance, the seller's assurance was held to be a term of the contract, not just a representation. Bannerman v. White.
Okay, so summarizing the term versus representation distinction. Still vital, especially for future promises versus existing facts. And courts use factors like relative expertise, Dick Bentley, Oscar Chess, suggesting verification, E.K. v. Godfrey, time lag, Routledge v. McKay, and the stated importance of the statement, Bannerman v. White, to help classify it.
You've got it. That sets the scene perfectly. Now let's go back to that core definition of an actionable misrepresentation and start breaking down its elements. First up, it must be unambiguous.
Meaning clear, not vague.
Precisely. It has to be clear enough that you can objectively say what was being asserted. If the statement is hopelessly vague or just a sales tough, you can't really claim you're misled by it because it doesn't mean anything concrete.
Is there an example?
The source materials point to Dimmick v. Hallett. In that case, land being sold was described in the particulars as improvable.
Improvable. That does sound a bit vague.
The court thought so too. It was considered too ambiguous, too much like mere puffery, to form the basis of an actionable misrepresentation claim. It wasn't a concrete statement of fact. So remember Dimmick v. Hallett for ambiguity?
Okay, unambiguous. Got it. Next, the statement must be false. This sounds straightforward, but I suspect there are nuances here too.
You suspect correctly. Legal falsity isn't always about a direct, outright lie. One really important area is the half-truth.
A half-truth. You mean saying something that's technically true but leaves out crucial information?
Exactly that. It's a statement that is literally true in what it says, but it creates a misleading impression because of what it doesn't say. And guess what? Dimmick v. Hallett pops up again.
Ah, the improvable land case.
The very same. Another statement made about the land was that it was let to paying tenants. Now, factually, that was true. There were tenants, and they were, at that moment, paying.
Yeah.
But as the seller failed to mention that those very tenants had already given notice to quit. They were on their way out.
Ah. So saying they were paying tenants was true, but omitting the fact they were leaving painted a completely false picture of the investment's stability.
Precisely. The court held that this omission made the literally true statement misleading. A half-truth can amount to a false statement in the eyes of the law. It's a key concept. Dimmick v. Hallett again.
Okay, half-truths count as false. What about statements that were actually true when they were first made, but then things change before the contract is signed?
Another critical point. The law generally treats pre-contractual representations as being continuing representations. They continue to speak right up until the moment the contract is formed.
Oh, mean it.
Meaning, if you make a statement that's true at the time, but then circumstances change before the contract is finalized, making your original statement false, you generally have a duty to correct it, to disclose the change.
And if you don't, if you stay silent,
Then your silence in the face of that changed circumstance can operate as a misrepresentation. The original, now falsified statement continues to mislead. There are two really key cases here you need to remember. With V. O'Flanagan and Spice Girls Ltd v. Aprilia World Service BV.
okay, with V.O. Flanagan. That was the sale of the doctor's practice, wasn't it?
It was. The seller told the potential buyer the income of the practice, and that figure was accurate at that time. However, between that statement and the contract being signed, the seller became ill and the practice's income dropped significantly.
And he didn't tell the buyer?
He didn't. His failure to disclose that drop meant his original statement about the income, though true when made, had become false by the time of the contract. His silence about the change was the actionable misrepresentation, with V.O. Flanagan.
And the Spice Girls case? Sounds more glamorous.
Oh, maybe. In Spice Girls Ltd v. Aprilia World Service BV, the group took part in promotional activities, photo shoots, and the like for a big sponsorship deal with Aprilia, the scooter company, before the main contract was signed. Their participation was seen as a representation that the group intended to continue as a five-piece. However, before the contract was finalized, one member, Gary Halliwell, had already told the others she intended to leave.
And they didn't tell Aprilia.
They didn't. Their failure to disclose this crucial change, which undermined the whole basis of the promotion, was held to be a misrepresentation. Spice Girls Ltd v. Aprilia World Service BV.
So both with V.O. Flanagan and Spice Girls show this principle. If circumstances change, making your earlier true statement false, you have to speak up. Silence becomes misrepresentation.
Exactly. It's the concept of a continuing representation coupled with a duty to disclose changes.
This brings us back to silence more generally. You said the basic rule is caveat emptor, let the buyer beware. Generally, no duty to volunteer information. How do these exceptions fit?
You're right, the general starting point, confirmed in cases like Keats v. Earl of Cadogan.
What happened there?
The landlord letting a house didn't tell the tenant it was in a ruinous condition. Because the landlord made no positive statement about its condition, just stayed silent, there was no misrepresentation. Keats v. Earl of Cadogan. So mere silence about a defect is usually not actionable.
Okay.
However, as we've just seen, silence can become misrepresentation in specific contexts, like the half-truth scenario in Dimmick v. Hallett, where silence distorts a positive statement, or the changed circumstances cases like With and Spice Girls, where silence fails to correct a previously true statement that's become false.
Are there any types of contracts where there is a general duty to disclose things, even if not asked?
Yes, there's a category of contracts known as contracts of utmost good faith,
Yeah.
or uber me fide.
Like insurance.
Insurance contracts are the classic example. The person applying for insurance has a positive duty to disclose all material facts relevant to the risk the insurer is taking on, even if the insurer doesn't specifically ask about them. Failure to do so can allow the insurer to avoid the policy.
Is there a case example?
Lambert v. Cooperative Insurance Society, Ltd., is mentioned in the materials. It involved non-disclosure of previous convictions relevant to a jewelry insurance policy. Lambert v. Cooperative Insurance Society, Ltd. But remember, this duty of utmost good faith applies only to specific, limited categories of contract. It's not the general rule.
The materials also briefly touch on this wider, more recent debate about a general duty of good faith in English contract law, citing cases like Yam Seng versus others expressing caution like Mid-Essex.
That's right. It's a really interesting and ongoing discussion, particularly regarding long-term relational contracts where parties work closely together over time. Some judges have been willing to imply duties of good faith in such contracts.
But has that changed the basic rule about disclosure during negotiations?
Not generally, no. It's crucial to understand that, as things stand, this debate hasn't created a general duty to disclose facts during normal pre-contractual negotiations. You still don't usually have to volunteer information unless you fall into one of those exceptions we discussed. Half-truths, changed circumstances, or contracts uber me fide. The basic caveat emptor principle for mere silence still largely holds in standard negotiations. It's an area to watch, but not a general disclosure requirement yet.
Okay, so silence usually, unless it's a half-truth, changed circumstances, or a special utmost good faith contract. Got it. Now, you also mentioned that the statement element doesn't just mean words, it can include conduct.
Absolutely. You can make a statement, a representation through your actions without saying a word. And again, the Spice Girls Ltd v. Aprilia World Service BV case is the perfect illustration.
Their participation in the photo shoots.
Exactly. By actively participating in those promotional activities organized by Aprilia, the group, by their conduct, represented that they intended to continue as a five-member group, which was the basis for the campaign. When that turned out to be false because of Jerry Halliwell's impending departure, which they didn't disclose, their earlier conduct became a misrepresentation. Spice Girls Ltd v. Aprilia World Service BV. Actions can speak louder than words, legally speaking.
Okay, so we have unambiguous, false, including half-truths, continuing repsilence on changes, made by statement, words, specific silences, or conduct. What about the next bit? Existing fact or law. This seems designed to exclude certain types of statements.
It is. Generally, it rules out statements that are mere opinion and statements about future intention.
Let's take opinion first. If I just say, in my opinion, this is a great car, that's not usually a misrepresentation if it turns out not to be great.
Generally, no. A statement of opinion is usually understood as just that, a personal belief, not a guarantee of fact, especially if the other person is equally able to form their own opinion. The classic case is Bissett v. Wilkinson.
What happened there?
A seller of land in New Zealand, which had never been used for sheep farming, told the buyer that he estimated it would carry 2,000 sheep.
That's an estimate, an opinion.
Yes. Both parties knew the seller had no actual experience of sheep farming on that land. So the court held it was merely a statement of opinion, genuinely held, and not an actionable misrepresentation when the buyer found it couldn't support that many sheep. Bissett v. Wilkinson.
But surely opinions can sometimes cross the line and become misrepresentations. It feels like they could be misleading.
They absolutely can. There are crucial exceptions where a statement that looks like an opinion is treated as a misrepresentation of fact.
Like when?
Firstly, if the person giving the opinion knows facts that are actually inconsistent with that opinion. An opinion often carries an implied assertion that the speaker knows facts that justify it. If they actually know facts that contradict it, then the opinion is effectively a misrepresentation of those underlying facts.
Okay, so the opinion implies a factual basis.
It's exactly. Smith v. Landhouse Corporation is the key case. A vendor selling a property described the sitting tenant as a most desirable tenant.
Sounds like an opinion.
It does. But the vendor knew that this most desirable tenant was actually seriously behind on their rent payments. That known fact completely contradicted the opinion. The court said the opinion implied that there were facts justifying it, like prompt rent payment, and that implied factual basis was false. So it was an actionable misrepresentation. Smith v. Land Health Corporation. Knowingly giving an opinion contradicted by facts you hold is a misrepresentation.
Right, so if you know your opinion is baseless on the facts, it's treated as a misrep of fact. What's the other exception?
Where the person giving the opinion has special expertise or skill regarding the subject matter compared to the person receiving it.
Ah, the expert opinion.
Yes. In this situation, an expert's opinion can be treated as implying that they have reasonable grounds for holding that opinion, that they've used their expertise properly to arrive at it. If they haven't, if they've been careless or lack a reasonable basis, their opinion can be a misrepresentation.
Is there a case for this?
Esso Petroleum Co. Ltd. v. Marden. We mentioned it earlier regarding common law negligence, but it's relevant here too. Esso, the oil company experts, gave a potential tenant an estimate of the likely petrol sales from a new site.
An estimate sounds like an opinion.
It does, but because Esso had special expertise in site assessment and predicting sales, their estimate was treated as implying they had carried out proper calculations and had reasonable grounds for that figure using their expertise. When it turned out the estimate was negligently prepared and wildly inaccurate due to planning changes they knew about, it was held to be an actionable misrepresentation. Esso Petroleum Co. Ltd. v. Marden. An expert opinion implies a reasonable basis.
Okay, so an opinion can be a misrepresentation if the giver knows facts that contradict it. Smith v. Landhouse Corp. Or if an expert gives it without reasonable grounds. Esso v. Marden. What about statements of intention? You said they're generally not facts either.
Correct. Saying, I intend to do X tomorrow, is usually about the future, not an existing fact. However, there's a very famous and important exception established in Edgington v. Fitzmaurice.
What's the exception?
If, at the time you state your intention, you do not actually hold that intention, then you are misrepresenting your current state of mind.
And your state of mind is considered a fact.
Exactly. Lord Justice Bowen's famous quote from Edgington v. Fitzmaurice sums it up. The state of a man's mind is as much a fact as the state of his digestion.
Huh. Okay, so what happened in Edgington?
A company issued a prospectus inviting loans, selling bonds essentially, and stated in the prospectus that the money raised would be used to improve buildings and expand the business.
Sounds like a statement of intention.
It was. But the director's actual intention, their real plan at the time they issued the prospectus, was to use the money to pay off the company's existing pressing debts, not for expansion.
So they lied about their intention.
They misrepresented their actual state of mind, their present intention. And the court held that this misrepresentation of their current intention was a misrepresentation of fact. Edgington v. Fitzmaurice. This is a really key principle to grasp. Falsely stating your intention is misrepresenting a current fact, your state of mind.
That's quite a neat legal point. Saying you will do something might be a promise, breach of contract if broken, but saying you intend to do something when you secretly don't is a lie about now, a misrepresentation.
You've nailed it. Finally, under existing fact or law, what about statements of law? Historically, these were tricky.
Why is that?
There was an old rule that everyone is presumed to know the law. Ignorantia juris, non-excuse. Ignorance of the law is no excuse. Based on that, a misstatement about the law wasn't considered an actionable misrepresentation because you should have known the law yourself.
So if someone wrongly told me, say, you don't need planning permission for that extension, under the old rule, I couldn't sue for misrepresentation if I relied on that and got into trouble.
That was the traditional view, yes. However, that has now changed. Following a major House of Lords decision, Kleinwort Benson Ltd v. Lincoln City Council, which dealt with recovering money paid under a mistake of law.
Yes.
The courts have since accepted that a false statement about the law can now be treated as an actionable misrepresentation. The case Pancania v. Hackney London Borough Council confirmed this modern approach. The old distinction is largely gone. Pancania v. Hackney London Borough Council.
So misstating the law can be a misrepresentation now.
Yes. And also, don't forget the Edgington v. Fitzmaurice principle applies here too. Even if misstating the law itself wasn't actionable, misrepresenting your genuine belief about what the law is would still be a misrepresentation of your state of mind, which is a fact.
Okay, so the old rule is history. False statements of law can be misrepresentations. Phew, that covers existing fact or law. We're on the final element. The misrepresentation must have induced the party to enter the contract.
Yes. This is about causation. Did the false statement actually persuade or influence the person to agree to the deal?
It has to be a reason they signed up, not necessarily the only reason.
Exactly. It doesn't have to be the sole cause or even the main reason. As long as it was a reason, a factor that played a part in their decision-making process, that's generally enough. This was confirmed back in Edgington v. Fitzmaurice. Yes, it's a very important case. And also, in the more recent case, BV Netherlands Industrie van Producten v. Rembrandt Enterprises.
Just a reason is sufficient.
It needs to play a real and substantial part, according to the court in Raiffeisen Central Bank Oostenrijk v. Royal Bank of Scotland split. So not a trivial or completely insignificant factor, but it doesn't need to be the dominant one. Real and substantial part.
And you mentioned earlier there's a presumption. If a misrepresentation is made, is it assumed it induced the contract?
Yes, and this is a really powerful tool for the claimant, the person who is misled. If Party A makes an actionable misrepresentation to Party B, and B then enters into a contract with A, the law presumes that the misrepresentation did induce B to enter the contract.
So the burden isn't on me, as the victim, to prove I was induced?
Initially, no. The burden shifts to the representer, the person who made the false statement, to prove that it did not induce the contract. And the Supreme Court in Hayward v. Zurich Insurance Colleague Hupel made it clear this presumption is very difficult to rebut. That case, Hayward v. Zurich, really emphasized the strength of this presumption. It's a key point to remember.
Okay, presumption of inducement is strong, Hayward v. Zurich. So how can the person who made the statement rebut it? How do they prove I wasn't actually influenced by their false statement?
They have to produce convincing evidence. The source materials highlight several ways they might try. One clear way is to prove the representee, the person misled, was actually aware that the statement was untrue when they entered the contract.
If I knew it was a lie, I couldn't have been induced by its supposed truth. Makes sense.
Exactly. But, and this is crucial, just having the opportunity to discover the truth isn't enough to rebut the presumption.
So, if they gave me a pile of documents that would have shown the statement was false, but I didn't bother reading them, I can still claim I was induced.
Yes. There's no general duty on the representee to verify the truth of statements made to them. The classic authority is Redgrave v. Heard. A buyer of a solicitor's practice was told it had a certain income. He was given accounts that actually showed a lower income, but he didn't examine them properly.
And he was still induced.
He was still held to be induced by the seller's verbal misrepresentation. The mere opportunity to discover the truth, which he didn't take, was not a bar. Redgrave v. Heard. Remember that one opportunity to check is not enough.
What about just suspecting it might be untrue?
Suspicion isn't enough either. Hayward v. Zurich, the insurance fraud case, confirmed that. The insurance company suspected the claimant might be exaggerating his injuries, but they didn't know for sure. They settled the claim. Later, they got proof of fraud. The court said their earlier suspicion didn't prevent the fraud from inducing the settlement. They needed actual knowledge of the falsity at the time. So, Redgrave v. Heard, opportunity not enough. Hayward v. Zurich, suspicion not enough. You need actual awareness.
Okay, actual awareness rebuts. Opportunity or suspicion doesn't. What else can the representer argue?
They could try to prove that the representee relied entirely on some other factor or inducement, something for which the representer wasn't responsible.
Like relying on their own investigation?
Yes, or the report of their own agent. The case is Atwood v. Small. Purchasers of a mine received exaggerated statements about its capacity from the seller, the vendor. However, before buying, they instructed their own agents to inspect the mine and report back. The agents mistakenly confirmed the seller's false statements.
So they relied on their agent's report, not the seller's original statement.
That's what the court held. Their decision to buy was induced by their own agents' faulty verification, not by the vendor's initial misrepresentation. The chain of reliance was broken. Atwood v. Small. Relying on your own checks can negate inducement by the original statement.
Interesting. So relying on someone else's confirmation, even if wrong, can stop you claiming inducement from the first person. What else?
Another way to rebut is to prove the representee simply wasn't aware that the misrepresentation had even been made.
Can't be induced by something you don't know about. Seems obvious.
It does. The case is Horsfall v. Thomas. A defect in a gun being sold was actively concealed by inserting a metal plug. However, the buyer purchased the gun without inspecting it at all.
So he never saw the plug or knew about the concealment.
Correct. He was completely unaware of the seller's misrepresentation, the conduct of concealment implying the gun was sound. Therefore, he couldn't have been induced by something he didn't know existed. Horsfall v. Thomas.
Makes sense. Awareness of the misrepresentation is necessary for it to induce. Is there a final way to rebut?
The representer could try the difficult task of proving the representee would have entered the contract anyway, on exactly the same terms, even if they had known the truth.
Basically, proving the misrepresentation made absolutely no difference to the decision.
Yes, but the source materials stress this is an extremely high hurdle. The representer has to positively prove this counterfactual scenario, not just speculate about it. The case, Atlantic Lines and Navigation Co. Inc. v. Hallam Ltd., the Lucy, indicates the difficulty. Proving definitively that someone's decision wouldn't have changed with accurate information is very tough. The Lucy.
Okay, so let's recap inducement. Strong presumption it induced, Hayward v. Zurich. Rebuttal requires proof representee knew it was false, Hayward, cf. Redgrave for opportunity, or relied entirely on something else, Atwood, or was unaware of the misrep, Horsfall, or definitely would have contracted anyway, the Lucy. High bars for the representer.
That covers it well. Now, just one more point related to inducement, materiality. Does the statement have to be objectively important, something a reasonable person would rely on?
Right, the materiality question. Is it a separate requirement? Does the misrepresentation have to be material as well as inducing?
The source clarifies that, strictly speaking, materiality isn't an independent requirement for misrepresentation to be actionable. You don't have to prove materiality in addition to inducement. However, materiality has a crucial impact on the burden of proof for inducement.
How so?
The case Muse Prime Properties Ltd v. Adhill Properties Ltd. explains it. If a misrepresentation is material, meaning it's the kind of statement that would influence a reasonable person's decision, then inducement is presumed. Materiality triggers that strong presumption we just discussed.
Ah, okay. So materiality is why the presumption of inducement is so strong in most cases. Because usually the misrepresentations people complain about are things a reasonable person would care about.
Exactly. But what if the misrepresentation is not material? What if it's something objectively trivial or even outlandish like this pen was once used by Elvis Presley?
Something a reasonable person probably wouldn't base a contract on.
Right. If the misrepresentation is not material, the claimant loses the benefit of that automatic presumption of inducement. They then have the burden of positively proving that they, personally, were actually induced by that non-material statement. It's not impossible, but they have to actively demonstrate their reliance. Dudurian Group International Inc. v. Sims supports this.
So materiality isn't strictly required, but it's practically very important. If it's material, inducement is presumed, mus prime. If it's not material, you have to prove you actually relied on it, Dodorian.
You've got it perfectly. Materiality shifts the burden of proving inducement.
Okay, so we've now fully dissected the definition. An actionable misrepresentation is an unambiguous dimmick, false, inkle half-truths, dimmick, continuing reps with Spice Girls, statement, and conducts Spice Girls, certain silences, of existing fact or law. Not opinion unless Smith or Esso exceptions. Not intention unless Edgington exception. Law now included Pancania, which induced the contract, presumed material mus prime, Hayward, rebuttable only by awareness, other reliance, unawareness, or would have, anyway, Redgrave, Atwood, Horsefall, the Lucy.
An excellent summary. The next critical step, the bridge to understanding remedies, is identifying the category or type of misrepresentation. This depends entirely on the state of mind or level of fault of the person who made the statement.
Right, because the consequences, especially the remedies available, vary hugely depending on how the false statement came about. Was it a deliberate lie or just a mistake?
Exactly. The source materials outline 4 main categories you absolutely need to know. Getting these clear is vital for any exam question. Remember these 4.
Okay, let's have them.
First, and most serious, is fraudulent misrepresentation. This involves proving the common law tort of deceit.
Okay, deceit. How is that defined?
The definition comes from the absolute landmark case, Derry v. Peake. A statement is fraudulent if it is made 1, knowing it is untrue, or 2, without belief in its truth, or 3, recklessly, careless whether it be true or false. Derry v. Peake.
So it requires actual dishonesty, basically. Knowing you're lying or just not caring if you are.
Yes, it requires a high degree of subjective dishonesty or recklessness. And, crucially, the burden of proving this fraud rests entirely on the claimant, the person alleging they were deceived. And it's a heavy burden. Courts don't find people guilty of fraud lightly. Derry v. Peake sets that high standard.
Okay, Category 1, fraudulent. Tort of deceit. High standard from Derry v. Peake. Claimant has the heavy burden. Got it. What's next?
Second, and this is often the claimant's preferred route if the facts fit, is statutory misrepresentation under Section 2, subsection 1 of the Misrepresentation Act 1967. You'll often just hear it called misrepresentation under Section 2.1.
And this is sometimes called the fiction of fraud. Why that name again?
Because the Act creates a clever legal mechanism. Even if the person making this statement wasn't actually fraudulent, didn't meet the high Derry v. Peake standard, the way Section 2.1 works means the claimant can potentially get remedies as if it were fraud, but with a much, much easier path in terms of proof.
Easier how? What does the claimant have to prove for Section 2.1?
Remarkably little compared to fraud. The claimant only needs to prove that 1, there was a misrepresentation. 2, it was made by the other contracting party. 3, it induced them to enter the contract. And 4, they suffered loss as a result. That's it.
So they don't have to prove the state of mind of the person making the statement at all?
Not initially, no. Once the claimant proves those basic elements, the burden of proof completely shifts to the defendant, the person who made the statement.
And what does the defendant have to prove to escape liability under Section 2.1?
They have to prove 2 things. First, that they had reasonable grounds to believe that the statement was true, and second, that they did actually believe it was true, right up to the time the contract was made.
Wow. That's a huge shift. The person who made the statement has to prove they weren't negligent and they genuinely believed it.
Precisely. And proving they had reasonable grounds can be very difficult. The case Howard Marine and Dredging Co. Ltd. v. Ogden & Sons Excavations Ltd. is a stark example.
What happened there?
A company hiring some barges was told their carrying capacity based on figures in the Lloyd's Register. The register was notoriously sometimes inaccurate. The barge's own shipping documents contained the correct lower capacity figures and were available.
So relying on the register wasn't enough.
The court held it wasn't reasonable grounds for belief when the accurate documents were readily accessible. The defendant failed to discharge the burden under Section 2.1. Howard Marine and Dredging Co. Ltd. v. Ogden & Sons Excavations Ltd. It shows how tough that reasonable grounds test can be.
Is there a case where the defendant did manage to show reasonable grounds?
Yes. The materials mention Al-Hassawi v. Nottingham Forest FC Ltd. In that case, concerning the sale of the football club, the buyer claimed misrepresentation regarding the club's liabilities. The seller had relied on information provided by senior club officers. The court found that, in the circumstances, relying on those officers was reasonable. Al-Asawi v. Nottingham Forest, FCLTD. So it depends on the facts, but the burden on the defendant is significant.
Okay, so category 2. Statutory misrepresentation under S.21 of the Misrepresentation Act 1967. Burden shifts to defendant to prove both reasonable grounds and actual belief. Howard Marine, Al-Hasawi. And it leads to remedies like fraud, the fiction of fraud.
You got the key elements perfectly. Now, category 3, negligent misrepresentation at common law.
This isn't under the Act.
No, this is based on the general law of torts, specifically the tort of negligent misstatement. The principles were famously established in Hedley Burn & Co. Ltd v. Heller and Partners Ltd.
Right, Hedley. What do you need to prove for this one?
Here, the burden is back on the claimant. They need to establish several things. That there was a special relationship between the parties giving rise to a duty of care, that the defendant breached that duty by making the false statement carelessly, and that this breach caused the claimant loss. Hedley Burn & Co. Ltd v. Heller and Partners Ltd. So proving duty, breach, causation, the standard negligence elements.
Essentially, yes. And the Hedley-Burn principle was confirmed to apply specifically to negligence statements made during pre-contractual negotiations in Esso Petroleum Co. Ltd v. Martin, that petrol station case again. Hedley-Burn v. Heller, Esso v. Martin.
Okay, category 3, common law negligent misstatement, based on Hedley Burn. Claimant must prove duty of care, breach, causation.
Correct. And the final category, number 4.
Innocent misrepresentation. Yes. This term is now used quite specifically. It refers to a misrepresentation where the person who made the statement satisfies the defense under Section 2.1. That is, they genuinely believed the statement was true and they had reasonable grounds for that belief. Essentially, they weren't negligent under the statutory test, and implicitly, they weren't negligent under the common law Hedley-Burn test either.
So innocent here really means without fault, not fraudulent, and not negligent either.
Exactly. The source materials use the term wholly innocent sometimes to make this clear, distinguishing it from the older pre-1967 use of innocent, which basically just meant anything not fraudulent. Now, with statutory and common law negligence recognized, innocent means genuinely non-negligent belief based on reasonable grounds.
Okay, so the 4 categories are fraudulent, Dairy v. Peak, deceit, claimant burden; statutory negligent, May 1967, defendant burden, reasonable grounds belief; common law negligent, Hedley-Burn, claimant burden, duty of care; and wholly innocent, non-negligent, reasonable belief. Understanding these is absolutely the key to figuring out remedies.
It truly is. It's the essential framework. Each category unlocks different potential outcomes for the person who is misled.
Thinking about it, you can really see how the law tries to differentiate based on culpability. From the deliberate lie and fraud down through carelessness and negligence to the genuine non-negligent mistake in innocent misrepresentation, knowing which box a situation falls into is definitely the critical first step towards understanding what happens next.
Absolutely. And that what happens next is precisely where we're going. The remedies. We've defined the problem, categorized the fault levels. Now, the crucial question, if you've been the victim of an actionable misrepresentation, what can you actually do about it? What does the law offer?
This is the really practical side of things, isn't it? You've signed a contract based on false information, you regret it. What are your legal options to try and fix the situation or get compensation?
The source materials focus on the 2 main potential remedies. First, rescission, which is about trying to undo the contract entirely. And second, damages, which is about getting monetary compensation for the losses you've suffered.
And as you've stressed, which of these are available and how damages are calculated depends heavily on which category of misrepresentation we're dealing with: fraudulent, negligent, common law negligent, or innocent.
Precisely.
Yeah.
Let's start with rescission. What exactly does it mean to rescind a contract?
Undoing it, right, putting things back.
Exactly. Rescission is what's called an equitable remedy. Its fundamental aim is to restore the parties, as far as possible, to the position they were in before the contract was ever made. It's about unwinding the transaction.
So if goods were exchanged, they get returned. If money was paid, it gets refunded.
That's the goal, putting everyone back to square one, wiping the slate clean as if the contract never happened.
And is rescission available for all types of misrepresentation, even innocent ones?
Yes, this is the key point. Rescission was, and still is, the traditional remedy that's available, in principle, for all categories of actionable misrepresentation, whether it was fraudulent, negligent under statute or common law, or wholly innocent. It's a potentially very powerful remedy.
You said in principle. Does that mean it's not always granted?
Well, first, remember the contract is voidable, not automatically void.
What's the difference again?
Voidable means the contract is valid and binding unless and until the innocent party chooses to avoid it, to rescind it. It requires action from the claimant. Void means the contract was never valid in the first place, a nullity from the start. Misrepresentation makes a contract voidable.
Okay, so the victim has to take steps to rescind. How do they do that? Usually by telling the other party.
Yes, the normal way is to give notice to the other party that you are rescinding the contract. However, sometimes that's not possible. For instance, if the other party has vanished, maybe after committing fraud.
What happens then?
The law is slightly flexible. If you can't notify the other party, taking all reasonable steps to show you're rescinding might be enough. The Case Car and Universal Finance Co. Ltd v. Caldwell is the authority here.
What happened in Caldwell?
A car was bought with a fraudulent check, and the buyer immediately disappeared. The original seller couldn't find the buyer to tell them he was rescinding. Instead, he immediately notified the police and the Automobile Association, the AA.
And that counted as rescission.
The court held it did. By taking those overt steps, informing relevant third parties as soon as possible, he had effectively rescinded the contract, even without direct notice to the fraudster. Car and Universal Finance Co. Ltd v. Caldwell. An important practical point if the other party absconds.
Good to know. But you also mentioned rescission is an equitable remedy. Does that mean there are situations where even if you have a right to rescind, you might lose it?
Yes, precisely. Because it originated in the courts of equity, the right to rescind isn't absolute. It can be lost through the operation of certain bars to rescission. The court has discretion. The source materials detail 4 main bars you absolutely must know for exams. Remember these bars.
Okay, 4 potential roadblocks to rescission. What's the first one?
The first bar is affirmation. This happens if the party who was misled, after becoming aware of the misrepresentation and also becoming aware of their legal right to rescind because of it, nevertheless does something that clearly shows they intend to carry on with the contract.
So basically, knowing you could get out, but choosing to stay in.
Exactly. If you affirm the contract, either explicitly or by your conduct, you lose the right to later change your mind and rescind. The case often cited is Long v. Lloyd. A buyer bought a lorry, discovered significant defects shortly after, which amounted to misrepresentations, but discussed sharing repair costs and even took it on another long journey afterwards.
That sounds like treating the contract as ongoing.
The court thought so. His actions amounted to affirmation, so he lost the right to rescind. Long v. Lloyd.
And you mentioned needing dual knowledge for affirmation, knowing the facts and knowing the legal right.
Yes, this is important. The case, Payman v. Lanjani, clarified this. You need to be aware not just of the facts that constitute the misrepresentation, but also aware that those facts give you the legal right to choose to rescind. Just knowing the facts might not be enough if you don't realize you have a choice. Affirmation, Long v. Lloyd, Payman v. Lanjani, dual knowledge.
Okay, affirmation is bar number 1. What's number 2?
Bar number 2 is lapse of time, sometimes called latches in equity. Basically, if you wait too long before trying to rescind, the court might say it's too late, especially if the delay makes it unfair to the other party.
How long is too long?
It depends. For fraudulent misrepresentation, time generally only starts to run from when the fraud was discovered or reasonably could have been discovered. But for non-fraudulent misrepresentation, negligent or innocent, the rule has traditionally been stricter. Time may start running from the date the contract was made, even if you haven't discovered the misrepresentation yet.
Wow, that seems harsh. You could lose the right before you even know you have it.
It can be. The classic case illustrating this is Leafy International Galleries. A buyer bought a painting described, wrongly, as being by the famous artist Constable. He only discovered it wasn't a Constable 5 years later.
And 5 years was too long.
The court held it was. Even though the misrepresentation was innocent, 5 years was an unreasonable delay to seek rescission. The right was barred by lapse of time. Leafy International Galleries.
Can shorter periods bar rescission?
Yes, depending on the subject matter and circumstances. The source also notes that the more recent case, Salt v. Stratstone Specialists Ltd., hinted that perhaps the time you become aware of the right to rescind might be more relevant now, questioning the harshness of the old rule for non-fraudulent cases. But Leaf remains important authority on delay. Lapse of time, Leafy International Galleries, maybe Salt v. Stratstone suggests flexibility.
Okay, bar 3.
Impossibility of restitution. Remember, rescission means putting both parties back exactly where they started, restitutio in integrum. If that's become impossible, then rescission can't happen.
What would make it impossible?
If the subject matter of the contract has been fundamentally changed, consumed, or destroyed. For example, if you bought ingredients based on a misrepresentation and you've already used them to bake a cake, you can't return the original ingredients. Clark v. Dixon is an older case where someone bought shares in a partnership which was later converted into a limited company. They couldn't return the original partnership shares, so rescission was barred. Clark v. Dixon.
But what if things have changed a bit, but not totally? Like if you bought a car and drove it for a while, you can't return it in brand new condition.
That's where the law has become more flexible. Courts now recognize that perfect restitution is often impossible. They may allow rescission if substantial restitution is possible, perhaps with a monetary adjustment to account for any benefit received or any depreciation.
So you return the car, but maybe pay something for the use you had of it.
Exactly. Equity tries to achieve practical justice. Erlanger v. New Sombrero Phosphate Co. allowed rescission of a mine purchase even though some phosphate had been mined and sold. An account for profits could be made. And Salt v. Stratstone Specialist Ltd., that case again, strongly reaffirmed this modern approach. Substantial restoration is often enough, and inability to make perfect restitution is less likely to be a bar now, especially if the representer caused the difficulty. Impossibility of restitution, Clark v. Dixon, old harsh rule, but now focus on substantial restitution. Erlanger, Salt v. Stratstone.
Good, that seems fairer. Okay, the fourth and final bar.
Third-party rights. This occurs if, before the original misled party tries to rescind the contract, an innocent third party acquires rights in the property for value without knowing about the misrepresentation.
Give me an example.
Okay. You are induced by my misrepresentation to sell me your valuable watch. I pay you, maybe with a bouncing check. Before you realize you've been misled and try to rescind the sale, I sell the watch to an innocent jeweler who pays me a fair price and has no idea about my earlier misrepresentation to you.
Can I get the watch back from the jeweler?
No, because the innocent jeweler acquired rights in the watch for value before you rescinded your contract with me. Their rights are protected. You lose the right to get the watch back from them. Rescission is barred against a third party.
So my only recourse is against you, the person who misled me, presumably for damages.
Exactly. You can't disturb the innocent third party's title. This is why, as the source notes, referencing Chapter 8 on mistake, sometimes victims of property fraud try to argue the original contract was totally void for a mistake, rather than just voidable for misrepresentation. Because if it was void, no title ever passed, not even to the innocent third party. But proving mistake is often much harder than misrepresentation.
Right. So, bar 4, intervention of innocent third-party rights, protects bona fide purchasers for value.
Correct. Those are the four main bars. Affirmation, Long v. Lloyd, payment, lapse of time, Leaf, Salt, impossibility of restitution, Clark but Erlanger, Salt, and third-party rights. Always check for these if rescission is being considered.
Got it. Now, is that everything on rescission? What about this idea of damages instead of rescission?
Ah, yes. This comes under Section 2, Subsection 2 of the Misrepresentation Act of 1967. This gives a court a discretionary power.
Discretionary meaning they don't have to award it.
Right. If a court finds that there has been an actionable misrepresentation, but it was not fraudulent, so negligent or innocent, it can declare the contract still valid and award damages in lieu of instead of ordering rescission, if the court thinks it would be equitable to do so.
When might a court do that? Why deny rescission if it's available?
They consider the impact on both parties. Perhaps the misrepresentation was relatively minor in the grand scheme of the contract, and forcing rescission would cause huge disruption or loss to the representer, disproportionate to the harm suffered by the representee. The court balances the fairness.
And that crucial case, Salt v. Stratstone Specialist Ltd., had something very important to say about when these S.2 damages are even available, didn't it?
Absolutely. Vital clarification came from Salt. Before that case, there was uncertainty. Could the court award S.2 damages even if the right to rescind itself had already been lost due to one of the bars, like lapse of time?
What did Salt decide?
Salt v. Stratstone Specialist Ltd. made it crystal clear. Damages under Section 2.2 are only available if the claimant still has a subsisting right to rescind at the time the court makes its decision. If the right to rescind has already been lost through affirmation, lapse of time, impossibility, or third-party rights, then the court cannot award damages under S.2.
That's a huge point. If you've lost the right to rescind due to a bar, you've also lost the possibility of getting S.2 damages in lieu. Salt v. Stratstone is key for that.
Absolutely a fundamental takeaway from Salt. You must have the right to rescind active when the court considers S.2 too.
Okay. If S.2 damages are potentially available because rescission is still possible but the court thinks damages are fairer, How are they calculated? What's the measure?
This is another area where the law isn't perfectly settled. The source notes there's no binding higher court ruling setting the exact measure. However, the most influential guidance comes from Lord Justice Hoffman, as he then was, in William Sindall, Plaitree, Cambridgeshire County Council.
What did he suggest?
He suggested the measure should reflect the loss caused by the property not being what it was represented to be. Essentially, the difference in value between what was received and what was represented, or perhaps the cost of putting the defect right.
Ah, like in the William Sindall case itself, there was an undisclosed sewer pipe under land being sold for development.
Exactly. The cost of relocating the sewer was estimated at around £18,000, whereas the land itself was bought for over £5 million. If the court decided rescission of the 5-meter contract was too drastic for this 18K issue, damages would likely be assessed based on that £18,000 figure, the cost incurred because the property wasn't as represented.
So it compensates for the damage caused by the misrepresentation, effectively the cost of fixing the problem or the reduction in value it causes.
That seems to be the likely approach. It's about compensating for the loss arising from the fact you can't rescind because the court won't let you, but you still suffered harm from the misrep. Note that if the misrepresentation is really trivial, the court might even refuse S22 damages altogether, as hinted in Harston Developments Ltd v. Bleakin. Williams Sindall, PLTV, Cambridgeshire County Council, Harston Developments Ltd v. Bleakin.
And quickly, Section 2.3 of the Act says if someone gets damages under S2121 and S2222, the court has to take the S.2 award into account. Does that tell us anything?
It suggests the measures might be different, or that S.22 damages might generally be lower than damages under S.21, which we'll come to next. Otherwise, there'd be no need to offset them. It hints at different purposes for the two subsections.
Okay, that covers rescission, with its bars, and the alternative of damages in lieu under S.22. Now let's move on to the main remedy people often seek for financial loss. Damages as a standalone remedy.
Right. And this is where knowing the category of misrepresentation becomes absolutely critical, because it dictates which legal action you bring for damages and, crucially, how those damages are calculated. The measures differ significantly.
Let's take them category by category. First, fraudulent misrepresentation. If you can prove fraud, using the Derry v. Peak definition, what action do you bring and how are damages worked out?
You bring an action in the tort of deceit. The measure of damages in deceit is the tortious measure.
Tortious measure means?
It aims to put the claimant back into the position they would have been in if the misrepresentation had not been made. It's sometimes called the out-of-pocket loss or the no-transaction measure. You're compensated for the losses caused by entering the transaction due to the fraud.
How is that different from the measure in breach of contract?
Breach of contract damages usually aim to put you in the position you would have been in if the contract had been performed correctly, if the statement, which became a term, had been true. This often includes compensating for your lost expectation or profit from the contract itself. Tort damages generally don't do that.
So for fraud damages, tortious, you generally don't get the profit you expected to make from the fraudulent contract itself.
That's the general rule, yes. You get compensated for the losses incurred because you entered the deal. However, there's an important addition. You can recover profits you lost on alternative transactions you likely would have entered into if you hadn't been deceived into this one.
Ah, okay. So if the fraud stopped me doing something else profitable.
Exactly. The key case for this is East v. Melwer. Buyers were fraudulently misled about why the sellers were selling their hair salon. They pretended they weren't going to compete nearby, but did. The buyers couldn't make the salon profitable.
What damages did they get?
They couldn't get the profits they hoped to make from the salon they bought. But they did recover damages representing the profits they likely would have made if they had bought a different, normally profitable salon elsewhere, which they had been considering. The fraud induced them into the bad salon, causing them to miss out on the good alternative. East v. Maurer. Remember that for lost alternative opportunity, profits in fraud.
Okay, so tortious measure, generally no contract profits, but yes to lost alternative profits, East v. Maurer. What about remoteness? Are damages limited to what was foreseeable?
This is a huge advantage of proving fraud. For damages in the tort of deceit, the claimant can recover all direct losses flowing from the transaction induced by the fraud, regardless of whether those losses were foreseeable. The normal remoteness rules don't apply to fraud.
All direct losses, even unforeseeable ones?
Yes. If the fraud caused the loss directly, it's recoverable. This was established in Doyle v. Olby, Ironmongers, Ltd. Fraud unravels all. Doyle v. Olby, Ironmongers Ltd.
So, fraud damages summary, tort of deceit, Dairy v. Peak, tortious measure, put back to pre-misreposition, no foreseeability limit, all direct losses recoverable, Doyle v. Olby. Can include lost alternative profits, East v. Maurer. Sounds quite potent if you can prove fraud.
It is. The House of Lords confirmed and elaborated on these principles in Smith Newcourt Securities, Ltd v. Scrimger Vickers, Asset Management, Ltd., reaffirming the aim is to compensate for all losses flowing directly from entering the transaction due to the fraud. Smith Newcourt Securities, Ltd v. Scrimger Vickers, Asset Management, Ltd.
Okay, now for the second category. Statutory misrepresentation under Section 2.1 of the Misrepresentation Act 1967. We know the claimant has an easier time proving liability because the burden shifts to the defendant. How are the damages calculated under S.21?
This is probably the single most controversial but most important point regarding S.21 damages. The Court of Appeal decided in the landmark case Roy Scott Trust Ltd v. Rogerson that the measure of damages recoverable under Section 2.1 is to be calculated using the tort of deceit measure.
Wait, really? Even though it might just be negligence, failure to show reasonable grounds, the damages are calculated exactly as if it were deliberate fraud.
Yes, that's what Roy Scott held. So, under S.21, the claimant gets the benefit of the generous deceit damages rule, the tortious measure covering all direct losses, irrespective of foreseeability.
Wow, that fiction of fraud label really means something then. You get fraud-level damages without having to prove actual fraud.
Precisely. Roy Scott Trust Ltd v. Rogerson is absolutely crucial. It means S.21 potentially offers the best of both worlds for a claimant. The easier burden of proof and the most generous measure of damages. Remember, Roy Scott v. Rogerson for the S.21. Damages measure, deceit measure.
That seems incredibly favorable to the claimant. Hasn't it been criticized?
Hugely controversial. The source materials explicitly note that senior judges, including law lords in the Smith Newcourt case, which was about fraud damages, expressed significant doubts about whether Roy Scott correctly interpreted Parliament's intention in S.21. They questioned equating negligence damages with fraud damages.
But it's still the law.
Yes. Despite the criticisms, Roy Scott has not been overturned by the Supreme Court and therefore remains the binding law on the measure of damages under Section 2.1. So, for exams, you must state the Roy Scott rule. Damage is assessed as a fraudulent, but it's also good practice to acknowledge that the decision is controversial. Roy Scott v. Rogerson equaled deceit damages, but note the controversy, Smith Newcourt.
Okay, SB21 damages follow the fraud rule per Roy Scott. What about contributory negligence? If the claimant was also a bit careless, can their S.2 damages be reduced?
This is another slightly murky area linked to the Roy Scott decision. There's a case, Grangelato Ltd v. Richcliffe, Ltd., which suggested that yes, damages awarded under Section 2.1 could potentially be reduced if the claimant's own negligence contributed to their loss.
Okay, so maybe contributory negligence applies.
But here's the inconsistency. Damages for the tort of deceit, actual fraud, are generally not reduced for the claimant's contributory negligence. The case Standard Chartered Bank v. Pakistan National Shipping Corp., Note 2, confirms this. Fraud overrides the claimant's carelessness.
So if Roy Scott says S.21 damages are calculated like deceit damages, shouldn't they also ignore contributory negligence like deceit damages do?
That's the logical puzzle. Roy Scott plus Standard Chartered suggests no reduction, but Grangelato suggests maybe there is. The law isn't definitively settled on whether the Law Reform, Contributory Negligence Acts 1945, applies to S.21 claims given their fraud-like nature under Roy Scott. So it's a point to raise. Grangelato suggests reduction possible, but it seems inconsistent with the Roy Scott deceit measure.
Okay, so S.21 is generally the claimant's best friend. Easier burden, Roy Scott fraud damages measure, but maybe a question mark over contributory negligence.
That's a good summary. Now, the third damage is action. Common law negligent misstatement, the action derived from Headley-Byrne.
Right. Here, the claimant has to prove the special relationship, duty of care, breach, causation, burdens on them.
Correct. We know it applies to pre-contract statements thanks to SOV Martin. How are damages measured here? It's the tortious measure, again, putting the claimant back to the position they were in before the negligent statement was made.
Same starting point as fraud and S.21, but is there a difference?
Yes, a crucial one. Unlike fraud, and unlike S.21, under the Roy Scott interpretation, damages for common law negligent misstatement are subject to the normal tort rule of remoteness. You can only recover losses that were a foreseeable consequence of the negligent statement.
Ah, so the all direct losses rule from frauds .21 doesn't apply here. Only foreseeable losses are recoverable under Headley-Byrne.
Exactly. Foreseeability acts as a limit.
Given that S.21 seems easier to prove and gives potentially better damages due to Roy Scott, why would a claimant ever choose to sue under common law Headley-Byrne negligence instead?
That's a very pertinent question. There are specific situations where Headley-Byrne is necessary, or the only option. Firstly, consider the type of statement. Section 2.1 applies to misrepresentations, false statements of existing fact or law. What if the statement was, say, a negligently given opinion by an expert that doesn't quite meet the strict exceptions, Smith or Esso, to be treated as a misrepresentation of fact?
It might still be a breach of a Headley-Byrne duty of care.
Potentially, yes. If a special relationship exists giving rise to a duty of care, a negligently expressed opinion might be actionable under Headley-Byrne, even if it doesn't qualify as a misrepresentation for the purposes of the Act.
Okay, so Headley-Byrne might cover negligent statements that aren't technically misrepresentations. What's the other key reason?
This is probably the most common reason. Headley-Byrne, or deceit, must be used if the misrepresentation induced the claimant to enter a contract with a third party rather than with the person who actually made the misrepresentation.
Can you give an example?
Imagine a financial advisor negligently advises you to invest in Company X. Relying on that advice, you buy shares in Company X. You don't have a contract with the advisor regarding the shares. You have one with Company X, or the seller of the shares.
So I can't sue the advisor under Section 2.1 because my contract wasn't with them.
Yes, exactly. Section 2.1 of the Misrepresentation Act only applies where the misrepresentation induces a contract with the representative themselves. This limitation was confirmed in Taberna Europe CDO2 PLC v. Selskabat. If the misrepresentation leads you to contract with someone else, your claim against the representative must be in deceit or common law negligence, Headley-Byrne. Taberna Europe CDO2 Sesley PLC v. Selskabat.
That is a really vital distinction. S21 only for contracts with the misrepresenter. If it's a third-party contract, you need deceit or Headley-Byrne.
Absolutely critical distinction to remember. So Headley-Byrne remains essential for those third-party contract situations and potentially for negligent opinions that aren't strict misreps.
Okay. That covers damages for fraud, Section 2.1, and common law negligence. What about the final category? Wholly innocent misrepresentation. Any damages available there?
No. If the misrepresentation was truly innocent, meaning the representative had reasonable grounds for their belief and wasn't negligent, then no damages are available as compensation for loss caused by the misrepresentation itself. Not under common law and not under Section 2.1, because they have a defense.
So if it's wholly innocent, the only remedy is potentially rescission.
Rescission is the primary remedy, yes, provided none of the bars apply. However, alongside rescission, the court might award an indemnity.
An indemnity? What's that? Is it like damages?
No, it's different and much more limited. An indemnity is an order requiring the representative to reimburse the innocent party for expenses they were legally obliged to incur as a direct result of the contractual obligations they entered into under the contract that is being rescinded.
So only costs directly required by the contract terms.
Yes. It doesn't cover general losses caused by the misrepresentation, like lost profits. It only covers expenses flowing directly from the contract duties themselves. The case is Whittington v. Seelheim.
What happened there?
Someone took a lease of farm premises based on an innocent misrepresentation that they were in good sanitary condition. They weren't, and the claimant's poultry died, and they incurred medical expenses. They also had to pay rates required by the lease and carry out repairs ordered by the council, also required by the lease terms.
What could they recover via indemnity?
They could recover the rates paid and the cost of the mandatory repairs, because those were obligations arising directly from the lease contract itself. But they could not recover the value of the dead poultry or their medical expenses, as those were consequential losses stemming from the misrepresentation, not direct contractual obligations. Whittington v. Seelheim. So indemnity at least only expenses required by the contract being rescinded.
Okay. So for wholly innocent misrepresentation, potentially rescission if no bars, plus maybe a limited indemnity for contractual costs, Whittington. No actual damages for loss.
That's the position.
Right, let's try and summarize the remedies quickly. Rescission. Available for all types. Fraud, negligent, innocent, undoes the contract. Bars are affirmation, Long v. Lloyd, payment, lapse of time, Leaf, Salt, impossibility restitution, Clark, but now substantial restitution, Erlanger, Salt, third-party rights. Remember Carr and Universal Finance for notice. Damages in lieu of rescission, S222 and MA, 1967. Discretionary, only if right to rescind still exists, Salt v. Stratstone. Replaces rescission if equitable. Measure likely cost of fixed difference in value, Williamson Dahl. Damages actions. Fraud deceit. Dairy v. Peak. Tortious measure, all direct losses, no foreseeability, Doyle v. Olby, include lost alternative profits, East v. Marr, see also Smith New Court. Statutory negligent, S.21, MA 1967. Burden shifts to defendant, Howard Marine, damages measured as if fraudulent, Roy Scott v. Rogerson, crucial but controversial. Contrib neg issue, Gran Gelato. Common law, negligent, Headley Byrne. Claimant burden, duty, breach, causation, tortious measure, but limited by foreseeability needed for opinions or third-party contracts. SO, Taberna, Europe. Wholly innocent, no damages, only rescission plus possibly indemnity. Whittington v. Sealhane. Wow, that's a lot to keep straight.
It is. But breaking it down by category and remembering the key cases for each measure and limitation is the way to manage it. You've summarized it perfectly.
Thinking about actually applying this, imagine you're advising someone who feels they were misled. You'd have to work through all these steps. What was said? Was it a term or rep? Was it actionable misrep? Which category? Which remedies are possible? Are there bars? It really shows how the law tries to tailor the response, quite specifically.
It does. It's a careful balancing act. And of course, parties sometimes try to influence this balancing act themselves by putting clauses in the contract beforehand.
Ah, yes, the attempt to dodge liability. Section 3 on the outline. Excluding liability for misrepresentation. Can parties just agree in the contract, okay, whatever we said before, it doesn't count, no liability for misrepresentation?
Well, they can certainly try. But the law puts significant controls on attempts to exclude or limit liability for misrepresentation, primarily to protect the weaker party or ensure fairness.
Are the rules different depending on who the contract is between, like consumer versus business?
Yes, the rules differ. For contracts between a trader and a consumer, attempts to exclude or limit liability related to what was said or written before the contract are primarily governed by the Consumer Rights Act 2015, CRA 2015.
And what does the CRA 2015 say?
Section 62 and Schedule 4 are relevant. Essentially, any term in a consumer contract which tries to exclude or restrict the trader's liability for misrepresentation will be subject to a test of fairness. If the term is found to be unfair under the CRA 2015 rules, it won't be binding on the consumer. We touched on the fairness test back in Chapter 6.
Okay, so consumers get the protection of the CRA 2015 fairness test for these clauses. What about other contracts, like business-to-business deals?
For non-consumer contracts, the main control comes from Section 3 of the Misrepresentation Act 1967. This section was significantly strengthened by Section 8 of the Unfair Contract Terms Act 1977, UCTA 1977.
And what does Section 3 do?
It states that any term in a non-consumer contract which purports to exclude or restrict liability for misrepresentation, or any remedy available for it, will have no effect except insofar as it satisfies the requirement of reasonableness, as stated in UCTA 1977, Section 11.
So for business contracts, these clauses are only valid if they are reasonable under the UCTA test.
Precisely. The burden of proving reasonableness falls on the party trying to rely on the exclusion clause.
And what does reasonable mean under UCTA S.11?
It's a broad test. The term must be a fair and reasonable one to have included, considering all the circumstances which were, or ought reasonably to have been, known to or in the contemplation of the parties when the contract was made. The courts look at factors like the bargaining strength of the parties, whether the customer knew or should have known about the term, whether the goods were made to special order, often guided by the factors listed in Schedule 2 of UCTA.
Is there a case showing this reasonableness test in action for misrepresentation?
The source mentions Aurora Fine Arts Investment Ltd v. Christie, Manson & Woods Ltd. as an example where the court considered the UCTA factors in relation to an auction house's conditions of sale limiting liability for descriptions. Aurora Fine Arts Investment Ltd. v. Christie, Manson & Woods Ltd.
And how do courts generally view very broad clauses that try to exclude all liability for misrepresentation in business contracts? Have they found them reasonable?
Often, no. The courts tend to scrutinize them carefully. Very wide-sweeping exclusion clauses, even if they are part of standard terms, are frequently found to be unreasonable. Cases like Walker v. Boyle and Thomas Witter Ltd. v. TVP Industries Ltd. are examples where broad clauses attempting to cover misrepresentation failed the reasonableness test. Walker v. Boyle, Thomas Witter Ltd. v. TVP Industries Ltd. Simply using standard terms doesn't automatically make them reasonable.
So, putting "we exclude all liability for pre-contract statements in a business contract" is risky. It might well be struck down as unreasonable.
It's definitely not guaranteed to work. And there's one type of misrepresentation for which liability cannot be excluded, no matter how cleverly the clause is worded.
Let me guess. Fraudulent misrepresentation.
Exactly. The law is absolutely clear on this. You cannot exclude or limit your liability for your own fraudulent misrepresentation. This fundamental principle was confirmed by the House of Lords in HIH Casualty and General Insurance Ltd v. Chase Manhattan Bank. HIH Casualty and General Insurance Ltd v. Chase Manhattan Bank.
So if someone deliberately lies to induce a contract, no clause can protect them from being sued for deceit.
Correct. Public policy forbids contracting out of liability for your own dishonesty. HIH Casualty is the authority.
Okay, that makes sense. Now, what about those clauses that are a bit more subtle? The ones that don't explicitly say, we exclude liability, but instead say something like, this written document contains the entire agreement between the parties, or each party confirms it has not relied on any statement or representation made by the other party.
Ah, yes. Entire agreement clauses and non-reliance clauses. These are very common, precisely as attempts to prevent misrepresentation claims by defining the contractual basis.
How does the law treat these? Are they caught by Section 3 of the Misrepresentation Act and the reasonableness test?
This has been a somewhat debated area, but the dominant and generally accepted legal position now is yes, they usually are caught. The courts have largely held that clauses which state that no representations were made or that no reliance was placed on any representations are, in effect, attempts to exclude liability for misrepresentation.
So even though they're phrased as defining the agreement, their substance is to exclude liability, bringing them under Section 3.
That's the prevailing view. Therefore, these entire agreement and non-reliance clauses must satisfy the reasonableness test under UCTA S. 1111 to be effective against claims for negligent or innocent misrepresentation. There's a line of cases supporting this, including Cremdinian Properties, Ltd v. Nash, Entrepreneur Estates, CPC, Ltd v. Worth, and Thomas Witter, Ltd v. TBP Industries, that case again. Cremdinian Properties, Entrepreneur Estates, Thomas Witter.
So the general rule is entire agreement non-reliance clauses are subject to the reasonableness test.
That's the safer and majority view. However, the source materials do acknowledge there have been some conflicting decisions.
Gotchas.
Cases like Watford Electronics, Ltd v. Sanderson, CFL Ltd, and an older case, Overbrook Estates, Ltd v. Glencombe Properties Ltd, which was decided before UCTA amended S.3, have sometimes suggested that certain carefully drafted clauses might genuinely operate just to define the scope of the agreement or the basis on which the parties contracted, an evidential estoppel, rather than actually excluding liability for representations that were relied upon. If viewed that way, they might fall outside Section 3.
So there's still a bit of legal uncertainty or tension here.
There is a degree of unresolved tension, as acknowledged in recent higher court cases like Raiffeisen Central Bank, Österreich AG v. Royal Bank of Scotland, Pilkeep, and Aurora Fine Arts Investment Ltd. v. Christie Manson & Woods Ltd. The precise line can be fine and depends heavily on the specific wording of the clause.
But for practical purposes, especially for exams.
For practical and exam purposes, the key takeaway is that these clauses are very likely to be caught by Section 3 of the Misrepresentation Act, and therefore must satisfy the reasonableness test to be effective against non-fraudulent misrepresentation claims. Follow the Cremdinian line of authority as the main rule. And crucially, remember that no matter how they are worded, they cannot exclude liability for fraud, HIH casualty.
Okay, that's clear. Entire agreement or non-reliance clauses. Probably need to be reasonable, S3 UCTA. Definitely can't exclude fraud, HIH casualty.
That's the safe harbor understanding.
Thinking about all that small print you often see at the end of contracts, this whole area of law is really grappling with how fair those clauses are, especially when they try to dismiss everything that was said beforehand to get you to sign.
Absolutely. It's the law intervening to prevent standard form contracts being used to completely shield parties from the consequences of potentially misleading statements made during negotiations.
We have really covered a huge amount of ground today, systematically working through the definition, the types, the remedies, and now the exclusion clauses, all based on these University of London materials. It feels like a good moment to pause and maybe consolidate the absolute key takeaways, especially for anyone listening with exams on their mind.
Definitely. Pulling the threads together is crucial for retention. Mastering misrepresentation really comes down to understanding these core building blocks: the definition, the vital distinctions, the different actions and remedies, and the rules on exclusion.
Right. So, step 1, always identify the statement. Is it a contractual term or just a representation? Remember those factors: skill knowledge, Dick Bentley, Oscar Chess, verification suggestion, EK, time lag, routage, importance, Bannerman. That dictates whether it's breach of contract or potential misrepresentation.
Step 2. If it's a representation, does it meet the definition of an actionable misrepresentation? Check each element. Unambiguous, Dimmick. False, Inklehand, half-truths. Dimmick, continuing reps change circs with Spice Girls. Statement, words, conduct Spice Girls, key silences. Existing fact or law. Not mere opinion unless mythos exceptions. Not mere intention unless Edgington's state of mind exception. Law counts now Pancania.
And did it induce the contract?
And for inducement. Remember the strong presumption, Bees rhyme, Hayward, and the tough rebuttal hurdles for the representer prove awareness of falsity, Hayward, Redgrave, reliance on other source, Atwood, represent D, unaware of misrep, Horsfall, or proof contract would have happened anyway, the loose. Step 3. Determine the category of the actionable misrepresentation. Is it fraudulent, deceit, Dairy v. Peak test, claimant burden, statutory negligent, MA 1967, defended burden shift, reasonable grounds belief test, Howard Marine, Al-Hassawi, common law negligent, Headley-Byrne tort, claimant burden, duty of care, or wholly innocent non-negligent reasonable belief.
Step 4. Analyze the remedies based on the category. Rescission available for all in principle, but always check for the bars. Affirmation, Long v. Lloyd, payment, lapse of time, leaf, salt flexibility, impossibility of restitution, Clark, Old Rule versus Erlanger, self-substantial restitution, third-party rights. Remember Car and Universal Finance for notice.
Also consider damages in lieu of rescission, the S2 Bay 1967. Is it available? Only if right to rescind still subsists. Salty Stratstone is vital. Is it likely court would exercise discretion? Measure probably cost to fixed value difference, William Sindall.
Then the main damages actions. Fraud deceit. Tortious measure, all direct losses. No foreseeability, Doyle v. Olby. Includes lost alternative profits, East v. Maurer, reconfirmed in Smith New Court. Statutory negligent, S21. Tortious measure, as if fraudulent, Roy Scott v. Rogerson Key, but controversial. Note contrib neg issue, Gran Gelato. Common law negligent, Headley-Byrne. Tortious measure, but limited by foreseeability. Needs duty of care. Vital for opinions, third-party contracts, SO Taberna Europe. Wholly innocent, no damages, only rescission plus perhaps indemnity, Whittington v. Seal Hain.
Step 5. Check for any exclusion clauses. Consumers. CRA 2015 Fairness Test. Non-consumers. MA 1967 SIH Casualty. Shining Point 3 UCTA S.1 Reasonableness Test. Avera clauses often fail. Walker, Thomas Witter. And the absolute rule cannot exclude liability for fraud, HIH Casualty. Remember, entire agreement non-reliance clauses are generally caught by S.3 Reasonableness Test, creme de line, despite some conflicting cases.
That structure seems like a really solid way to approach a problem question. Identify, classify, actionable, Kittaker category, remedies, rescission plus bars, recreates plus petition plus co, damages action plus measure exclusion clauses, and apply the key cases at each stage. Repeating those case names really helps lodge them.
Absolutely. Let's quickly recap some of the most essential ones. Dairy v. Peak, fraud definition. With V.O. Flanagan and Spice Girls, change circumstances, continuing reps. Edgington v. Fitzmaurice, intention state of mind. Headley-Byrne v. Heller, common law negligence. Misrepresentation Act 1967, burden remedy S22 damages in lieu, S.3 exclusions. Howard Marine v. Ogden, defended burden. Roy Scott v. Rogerson, S21 damages measure like fraud. Salt v. Stratstone Specialist Ltd, S222 subsisting right, restitution, lapse of time. Doyle v. Olby, fraud damages all direct loss. East v. Marr, fraud damages alternative profits. Redgrave v. Hurd, inducement opportunity no bar. Hayward v. Zurich, inducement presumption awareness. Atwood v. Small, inducement the other reliance. Worth Fall v. Thomas, inducement unaware. William Sindall measure. HIH casualty v. Chase Manhattan cannot exclude fraud. Creme diem properties line, entire agreement clauses. Knowing what each case stands for is key.
It really is. Well, this deep dive has certainly taken us through the mill on misrepresentation. From defining it, understanding the types, exploring the powerful remedies like rescission and the different damages measures, and finally looking at how the law controls attempts to exclude liability.
Mastering these concepts and the associated case law really is fundamental to understanding so many contractual disputes that arise from things said before the contract is finalized.
And we must reiterate our sincere thanks to the University of London for making these incredibly detailed and useful educational materials available. We truly hope this discussion based on those materials has been a valuable learning resource for all of you listening.
And thanks once again to our sponsor, Sinorbit Academy Sri Lanka, for supporting this deep dive.
As we've seen throughout this discussion, the law of misrepresentation is constantly trying to strike this difficult balance, isn't it? Between the traditional idea of buyer beware, you look after your own interests, and the need to protect people from being genuinely misled by false or inaccurate information.
It really is. It's a system that acknowledges that while you have a responsibility to be careful, the law should step in when someone crosses the line with an actionable false statement that causes you to contract.
It definitely leaves you thinking, especially as we navigate a world with ever more complex information and transactions. It makes you ponder, how should the law balance that responsibility for disclosure versus the responsibility for verification? What equilibrium feels right?
That's a great question. What balance do you, listening now, think is fair in today's commercial world? It's certainly something legal systems continue to grapple with, especially around ideas of good faith and disclosure duties.
Food for thought as you continue your studies or just navigate your own agreements. And one last time, for everyone preparing for exams based on these topics, we genuinely wish you the very, very best.
Good luck for all of you for the exam. You've put the work in. Trust yourself.
Absolutely. Thank you so much for joining us for this deep dive into the intricacies of misrepresentation in contract law. We hope you found it helpful, and we'll catch you on the next one.
Until next time.